Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and this morning I'm looking at a book which has come to us from Contrcat. Now, this is an important book. It's been published in connection with Contrcat, and this is the European Contract Law and Theory Volume 1 publication. It's on the rules and principles of European contract law. Now, you probably think, why am I reviewing this particular book now, in the late summer, after a decision in June 2016 to leave the European Union made by the United Kingdom? Well, the reason we are is because whatever happens, we're still going to need to know what the principles are, because we're still going to be contracting with European colleagues, notwithstanding the decision, which I did not support, of leaving the EU, which I think has been a bad decision. That having been said, the two editors of this work, Contrcat, produce high quality academic argument. Obviously translations come into this, but I think they achieve a very good standard for us in this country with the persuasive authorities they put forward with their views. But the two editors, Jacobin Rutgers and Pietro Serena, have produced, I think, an important work here, because what they're trying to do is to give some indication to us as to where we're going with contract law. Now, contract law is a cornerstone of certainly the English legal system, and contract law as a general picture is something which affects every country throughout the world, whether they're dictatorships based on various forms of ideology or just complete autocratic regimes, or in fact capitalist democracies. The fact is that contracts are entered into all the time by everybody, and you've got to have rules and you've got to have principles. Now, clearly we've had principles and we have rules within the European Union, and the important point is to see where the United Kingdom will be in the future concerning its relationship with what we know as the European Court of Justice, or the Court of Justice of the European Union, depending on what you want to call it. Now, let's just have a look at the book first of all. Here is the book. It's an orange colour. It's the front. There is the spine. It's not a big book. It's a paperback. You can see the back. There is the collaboration team there. Contrcat logo, and then the Contrcat. I imagine that's how they pronounce it. There's their logo there, and then there's, of course, the actual website. You can see the very basic detail that's in it. Now, at the back, what you don't have with a book like this is you don't actually have any form of index. It runs 260 pages. There's no index at the back. And bear in mind that it's been translated, so there will be some differences in the way in which the work flows in terms of its English. There's the front page. Now, there is the series concerning European contract law and theory on the side there. You can see the number of people who are involved in the editorial board. Then you've got a lot of information and contacts from both in this country, in America and in Belgium. Then after that you've got the content section itself. There is no preface as such. There's the rest of the content section. It runs to it's not actually numbered, but you've got 1, 2, 3, 4, 5, about 9 or 10 chapters plus an introduction, and it looks very much at the way in which the whole principle of European contract law is going. Those are the tables of cases, and then from the various courts you can see Germany, Israel and so on, and a couple from England, Britain. Then you've got the list of the authors, a lot of people, collaborative work. Then you've got the introduction by the two main editors. And they quote, I'll give you a quote here. The general principles of community law have constitutional status, while the principle proposed by Audiolux is characterised by a degree of detail requiring legislation to be drafted and enacted at community level by a measure of secondary community law. Therefore, the principle proposed by Audiolux cannot be regarded as an independent general principle of community law. And that's actually from the case itself. and you've therefore got these words are part of the ruling of the European Court of Justice in the Audiolux case, which the question at stake was whether a minority shareholder in a company under Luxembourg law could rely on the general principle of equal treatment in EU law to secure its position. Now you can see one of the reasons why Britain has taken the decision to leave the EU is because they haven't been very happy, apart from the general dissatisfaction, they've not been happy about the way in which we've wanted to standardise certain things. One area which we had been looking at, because obviously it does affect trade, is the whole area of contract law. So let me just develop that theme a little bit, because in its case law, the European Court of Justice of the European Union, and they feature as the main list of cases in this publication, they have acknowledged general principles in existence of EU law which have a constitutional status. Now this is where the problem has obviously arisen with the United Kingdom, because in addition the Court of Justice has also recognised general principles of civil law relying upon values which are traditionally rooted in the domain of private law. Now I want to say one thing about that, and that is that with the decision to leave the European Union, one of the things that I believe the government departments in the UK will be tasked with is to try to save those areas of law coming from the directives and coming from the European Union and the old common market, the old EC. They're going to try and save those parts of the law that we currently have as laws in force because they will be beneficial to this country. Now that is going to be a very, very substantial task for many lawyers, but I do think that that is what is going to happen. So this work will be of some help, I think, to those people as they deliberate. The pervasive use of principles, both in the case law of the European Court of Justice and in other European Union projects of soft and hard law, is actually a problem because it challenges legal scholarship. And although the concepts of principles and rules have been widely discussed within the context of national legal orders, in other words the member states' orders, they need to be rethought at the European level, and that's clearly something that is going to happen because the reverberations from the decision in the UK referendum to leave Europe are going to affect a very large number of people. Obviously the traditional view of a principle that does not fit the European Union's constitutional architecture is going to be a problem in future. I don't know where we're going to go with that because we were moving very much to a form of standardisation. I hope that we can keep some of that, but I do see very substantial changes coming about. Of course, the points that I'm talking about also apply to general principles of civil law. For instance, good faith itself, which is a basic concept which of course runs through most jurisprudence that we have. There also have to be other matters that need to be refined to be consistent with the European Union's legal order. Where Britain is going to figure in that in the future is something I cannot answer at the moment, but I think the beauty of this book is to give you some idea of where we are at the moment with contract law from the contributors' points of view, with a view to seeing where Britain might be going in the future. Let me conclude by saying again from what is in the book that the contributions and the contributors to this book examine European Union general principles and their distinctions from rules both within the context of the European Union as well as that of the member states themselves. And moreover, they focus on the relevance of European Union general principles for contract law and the principles of civil law for a European contract law. That's something I've always really been quite keen to see where we could get some measure of agreement, bearing in mind our own common law system here in England and Wales. However, I think, unfortunately, with decisions being taken the way they have, we could be possibly taking a backward step. But I have to be very careful what I say concerning that. The publication date, of course, of the book is 2016. I'd like to thank the two authors, Jacobin Rutgers and Pietro Serena, very much as the editors. There's the book again. the spine and then the back, and you can see in the book itself the actual people who have contributed. Quite a large number there, just to show, to list them. But you get some idea of the overall concepts that are being put forward. As I say, you've got a couple of very standard cases listed from the UK and the US, but the rules and principles of European contract law are reasonably well set out here. There is, of course, in the book itself quite a lot of footnoting, which is of use, I'm sure. Whether this book is going to have any longer term influence on where we're going within the within the United Kingdom as far as the EU is concerned, because of the time scale, I do not know. But I'd like to thank everybody concerned for an excellent book, because it certainly is a very useful indication of where we are at the moment as we start looking at a new future. Thank you anyway to Intercentia and to their colleagues and to everybody involved in an excellent publication. Bye-bye.